Hi, Luke Carlson of Ellis Carlson Law. Welcome back to our podcast. Today we have Jenny on the show. Jenny, welcome.
Thank you for having me.
Thanks for being here. And of course, our producer, Marty.
It's always good to be back.
Thank you. And today I'm really liking this topic. This is neighbor disputes in the context of an association. Again, we're analyzing this from a California perspective. And I like this one specifically because we see this all the time.
Yeah, I'm really interested in this because when I think of HOA dispute, I don't think of problems with my neighbor. Why does an HOA ever come into play in this? So this is going to be fascinating from my perspective, at least.
Yeah, if you look back at our shows, it is specifically an issue with the association, and it's always association versus homeowner.
Right.
And so when neighbor dispute gets brought up, most people say, well, what does the association have anything to do with a neighbor-to-neighbor dispute?
Exactly.
And I think that's
exactly what I'm asking.
That's why we're here.
Yep. Okay. Fair enough. So let me lay the groundwork on this. So often when we look at an association, you say, okay, you have CC&Rs, which is a contractual relationship. And the understanding typically is the contract is between the association as entity and the owner of the property. Often, though, people don't understand that contractual relationship is also neighbor to neighbor. Meaning, if you have a neighbor who's violating the CC&Rs, who is impacting you, and we'll get into that impact in a moment, but that potentially could become a breach of contract because they owe you certain contractual obligations as a neighbor. So it's not always just association neighbor. Neighbor to neighbor also has that contractual CC&R foundation.
It's so interesting because I feel like people don't realize that.
No, it certainly did. It's one of those things. Well, in our CC&R, it says, you must talk nice to me. And you're not talking nice to me.
Yeah, well, I think
Kind words, please.
there is that. There's this element of decorum. They want to.
Is there really?
There should be. That's kind of the purpose of an association in the first place, right? To show respect for neighbors. You do that through maintaining your property by, ensuring that, you don't have 7 cars in your front yard. Stuff like that, right? Because it's typically prohibited by the CC&Rs. So you're trying to preserve property values. You're also trying to preserve your right to quiet enjoyment, the right to enjoy your property. So CC&Rs serves as a protection, or at least in theory, it should. So the question often becomes is, well, I live in a community. I don't necessarily have an issue with my association, but my neighbor is out of their mind. They're lunatics. They don't respect anyone. They don't respect me. And because of that, because of what they're doing, it's impacting my life. And that's really the context, I think, of this podcast, right? That's what we're talking about.
Yeah.
So, Marty, if you want to take the lead and kind of walk me through this, and I can sort of opine.
Answer any questions.
So, I wrote down a few different things here. The first one we briefly talked about, but I think it's worth repeating. CC&R violations. So neighbor on neighbor are violating CC&R.
So let me try to think of one that would directly impact a neighbor because it's.
Can I offer one example? Just because I've seen it in our neighborhood, is when people walk their dogs and pooping on the lawn.
Yeah, that could be one right there. That's actually a good one. You might have something in the CC&Rs where it's pick up your dog's waste. If that's not happening, you might have a direct claim against your neighbor for that. That might be a violation of an express provision within the CC&Rs, and that could be neighbor to neighbor. Another one could be maybe the neighbor is engaging in some sort of commercial activity, right? They're in their backyard sawing all day or creating a nuisance or creating noise or, doing something that in the CC&Rs it says you absolutely cannot do this. There's no commercial activity, yet your neighbor is engaging in a commercial activity. You may very well have a right to go after your neighbor to stop that behavior. And again, it's under this theory of breach of contract.
Yeah.
So, I've seen a scenario where someone was running a bike shop out of their garage.
Yeah. Or we know people running Pilates studios, whatever it is.
Whatever it is. And the issue there is you have high foot traffic, you have people coming in and out, and that can become very problematic. That becomes its own form of nuisance. So in that scenario, the neighbor would have a potential claim against the other neighbor for the violation of the CC&Rs. So that's one way to sort of conceptualize these disputes.
Okay, I'm going to ask this now, but I'm sure we're going to get into this. So when you have something like that, does the HOA actually get involved? And feel free to say, let's wait until we get down the list a little bit because I just got to get that out now because I want to get that answered.
Yeah, so let's talk about that. So to the extent that the association is aware of an open, outstanding violation of the CC&Rs, there is an obligation of the association to investigate and to potentially enforce. So what's interesting in these disputes, let's take the neighbor dispute. Your neighbor is engaged in a commercial activity, is creating a real nuisance, right? Maybe it's high foot traffic, noise, etc. So you have this ongoing. You notify the association, and the association says, we're not going to do anything. We don't care. We're going to allow them to do it.
And I've seen that happen in a lot of this Reddit. When I was looking for Reddit items, they say, well, the CC or the HOA says, hey, it's not really our business. It's between you two.
Right. And so, where an attorney could come in there is really determine whether or not it is truly neighbor to neighbor. More often than not, though, when there's an outstanding violation of the CC&Rs and the association is doing nothing, what becomes interesting legally is the homeowner might have two options or two sort of areas of attack. One, against the association for failure to enforce. The association has a fiduciary to you to enforce. I mean, that's really their function, right? Is to enforce CC&R violations. And so to the extent that they're not doing it, again, it might be a breach of fiduciary. It might be a breach in and of itself of the CC&Rs. So that's part one. So you might have a claim against association. And then you flip it over, you might have a direct attack against your neighbor as well. So you have two fronts. So, I mean, I guess to conceptualize it, it puts you in a relatively powerful position, right? You're putting pressure on the association. You're putting pressure on the neighbor. Now, really, the theory is if you're going to put pressure on the association, what do you want them to do? You want them to enforce.
Sure.
So you might come aggressively at the association, which might then force their hand to actually use their enforcement mechanisms against your neighbor. And that could be an effective way to go after this type of dispute. I hope I didn't jump ahead too much.
No.
Okay.
That's interesting. All right. Let's jump into the use of common areas. So that would be, pools, parks, parking areas. I feel like parking is such a lightning rod for disputes.
Parking is huge. It's a huge bone of contention. And, that's a byproduct of a number of things. One, people just don't care and they don't respect the rules. And you have an HOA who doesn't enforce, or there's massive ambiguity around the space.
And I feel like it could get tricky in instances like the community pool. So once that little lot is filled and you have a street next to a community pool or any community, what do you call it? Grassy area.
Common
whatever.
area.
Common area.
Park,
Thank you.
Yeah. Greenbelt.
Once the parking starts to go past the parking lot, and then people are impacted who live on that street right next to the common area.
Yeah. So I think what you're getting at is overflow. How does that work? How does that interact with designated parking areas? But parking, I think, too, becomes an issue because it sort of becomes a friction point for homeowners, right? Someone is parking incorrectly and now taking your spot, or someone frequently has guests, or the sort of the situation with the commercial enterprise, right? All the parking spots are being used because you have someone who's a customer and they're parking there and they're impeding your right to use it.
Correct. I feel like this happens probably more frequently in something like a condo association where you're only designated so many parking spots and they're not marked either. And they say, well, you have to park all vehicles inside of the garages. And then they run out, but no one's really abiding by that, and you have nowhere to park.
So definitely condo association, you see that quite a bit. You also see it, though, with the question about commercial vehicles. That becomes an issue as well.
Oh, like if you were the bread man and you drive your truck home every day?
Right. What constitutes a commercial vehicle? So that's a huge issue within the association context in terms of disputes, right? A lot of, like I said, disputes come out of parking. But if you go to the common area as well, utilization of the common area can create a neighbor dispute, especially if there's a green belt. What I've seen before is a homeowner will consistently use the green belt, will put patio furniture on the green belt, and it's just not, they don't have the right to do so.
Oh, and the bench?
Yes, the bench.
The bench with that poor man.
Yeah, exactly. We watched that news article on that.
The John Oliver video.
Yeah, exactly. So
that was an episode.
Go back to that one.
Go back to that one. That's a good one. So let's talk about noise and nuisance complaints. When I think of neighbors and problems with neighbors, this is the one. This is the Mount Everest.
You are 100% correct. Noise and nuisance. So how does this arise? Well, condos. Let's start
Alcohol.
Alcohol, yeah.
Alcohol, 100%.
Yeah, you're not wrong. So, you see this in the condo frequently. Often it's an upstairs neighbor who is just relentless on the flooring. They're tap dancing in the middle of the night. They have big parties.
Dogs or cats or animals.
Dogs, cats,
Yes.
animals, music, especially close quarters. It's just going to lend itself to that.
And some CCNRs, I've know too much about this topic now, but I've seen some CCNRs require a homeowner that they have to put in carpet if they're like a second or third row or higher. If you're not ground level, you're required to put carpet in for those noise restrictions. So there could be a contentious bone to pick if someone decides to put in, I want this hardwood
tend to do a
flooring
remodel.
or laminate.
Yeah.
Yes.
So, so it's often in the reverse, no hardwood flooring.
Right.
That's what it says.
Right.
It doesn't say
Yeah.
carpet.
Yeah,
it says
sure.
the opposite, right? But then you have someone who comes in, puts in flooring, and is now creating an ongoing nuisance, and they don't want to rip it out because they spent a lot of money on it. But at the same time, it's someone else's life has become a living hell, right? Because I've actually experienced that before, where in law school
We had that toddler that lived above us that had a walker, and that would just zoom. It was a fast little guy.
It was endless, and I understand.
Like a walker.
Like the little walker that they sit in
Yeah.
when they're learning to walk, and it has little wheels on it, so he would just roll. Do you remember
And
that?
it was so loud; it sounded like thunder every couple minutes, and
It was adorable.
it drove me crazy. So I can empathize with this situation. And then sometimes it's even compounded when it's at night. It's in the middle of the night. Someone was working odd hours. So there you have a nuisance that's ongoing, and that's interesting. Now, when you look at it from a HOA perspective, right? So if the association knows, let's say that there's hardwood flooring, I would argue they would have an obligation to correct or enforce.
Sure.
Often what the association will do at that point would, take some action against your neighbor and maybe force their hand to put carpet or put some sort of protective layer on the flooring. And that can become a fight unto itself, but at least, you're now leveraging the association on your behalf. Now, if the association isn't doing anything, again, you probably have some claim against the association for failure to act or failure to enforce. Again, breach of fiduciary, possible breach of CCNRs. But you would have a direct line of attack against the neighbor. And there it might be, breach of CCNRs, nuisance, you have this ongoing nuisance claim, etc. So that could also become a very direct way where you can enforce your rights against a noisy neighbor. So
Interesting. Let's go to architectural and aesthetic disputes. So I'm assuming neighbor painted the house or did something. Maybe I would assume a lot of fence disputes in here as well.
yeah, let's go into architectural first, because typically that is with the association.
Sure.
Right. I mean, someone, let's say they paint their house fuchsia, it's not permitted within the CCNRs. If you're the neighbor and you have to look at that every day, probably your best attack there is just to put the association on notice.
Yeah.
I don't know if you want to spend the resources and time trying to fight that fight when really it would be the association's
Sure.
fight in the first place. Now, where we get into fences and the like, there you might have an encroachment issue. And that can get interesting. So let's say someone puts up a fence and it encroaches into your property. So encroachment or trespass, right? They're actually in your property. What would be interesting to see is whether or not that fence was approved. And so to the extent that the association approved it, meaning they looked at this application and they said, this is wonderful, no issue, and they missed the fact of the encroachment, it's possible that you would have a claim against the association. That could be a negligence claim.
Would the HOA at that point be liable?
Well, again, it would be negligence, right?
Sure.
So they failed in their responsibility to properly approve, and as a result, you've been damaged. How were you damaged? Well, now you have a trespass. You have a fence that's encroaching onto your property.
Right. But the other neighbor on the other side might say, well, you approved this. I'm not taking this down.
Yeah, so
And
the association
so now
might be in a challenging spot, right?
Yeah.
So that could get interesting legally, or is it, possibly the architect that the neighbor hired to do the plans? Did they screw up? Is that some sort of professional negligence? Someone dropped the ball somewhere, unless it was malicious and intentional. That's a different story. Hard to prove. But, from the application itself, if they were dealing with accurate maps, it should have been very easy to identify where the boundary line is. Or is it a contractor dispute? Meaning the application was properly approved, the architectural plans were accurate, but you had some contractor who screwed it up and put it 3 feet encroaching into the other property. So these can cut in a lot of different ways. I think for our purposes on this podcast today, though, it's, identifying that you have rights there, and it could be a direct attack against the neighbor to sort of force their hand to push it back, or it could be against the association to, use their enforcement mechanisms to, compel or force your neighbor to bring that fence back to the boundary line or wherever it is, if there's a setback.
Sure.
I feel like the neighbor-neighbor dispute would get interesting specifically in construction because there's a reasonable amount of noise that's going to happen. But I could see how if they feel like there's excess noise or if it goes above what's decent.
I read it on Reddit that the laws and the CCNR say that construction can start at 7. One neighbor threw a fit and said, no, you can't start until 8. And just again, lightning rod.
Yeah.
Well, construction, I think, turns on two things. First and foremost, was the application approved or was the construction approved in the first place? Now, you get into scenarios where someone comes in, let's say it's your neighbor, and does construction without the appropriate approval of the association.
Does all call me ignorant, but does all construction need the approval of the HOA?
It
Getting a
depends.
bathroom redone.
It depends.
Oh, the famous
it
attorney.
Where's the mug? Where's the mug?
We
You
have
need like a bell.
Yes.
Ding.
possibly. So what you're looking at there is the CCNRs and the regulations around sort of the Architectural Control Committee. So what do they require? And normally what we see or what's very common is anything outwardly facing, it tends to have to go through the Architectural Control Committee. Any sort of foundational or structural issues, typically, yes, you have to bring it through the board or the committee. More minor cosmetic changes, maybe not. But you have to look at the governing documents or you have to look at the guidelines that sort of are attached to the CCNRs.
Now, if we've covered this a little bit, but let's just say in the sake of we're getting a bathroom or some sort of interior work done, has no bearing on the HOA itself. And they want to get started at a certain time. The state and local laws says that you can start at 7, but the CCNRs say, no, sorry, you have to start at 8. Is there a conflict there? And
that's interesting. The CCNRs that I've historically seen are consistent with city and
local laws,
local ordinances. I've never seen it really modify that. I don't know offhand what would prevail because it's a contractual term. I don't know.
It's interesting.
Yeah.
Well, maybe we'll circle back.
I haven't seen that come up. I mean, listen,
footnote.
if it comes up, we can obviously research it. And take a
I
look.
like to throw the weird ones at you.
That's a weird one. I've never seen a conflict between the two. I mean, normally they set it to whatever is common within the community or county or state, right?
Sure.
I just had a friend deal specific with the noise of construction, what was considered reasonable noise and what was considered excessive noise, and that became a neighbor to neighbor.
Was that in the
was
context of an association?
Yes.
Interesting.
And I forget how it panned out, but I thought that was just interesting.
Often it comes down to a battle of experts. And again, kind of going
Measuring
back.
decibels?
No, seriously, they will. Do they need a jackhammer 24/7? And then you also have to look at
Excessive jackhammering.
whether or not what they're doing falls outside of the scope of the application.
Interesting.
Because that's very common. And when that happens, the person who's doing construction outside of that scope is going to have massive problems.
Do they ever have an issue where, again, your work in interior has no bearing on any sort of architectural control guidelines or anything like that, but where people park and how way do we take away trash and how they
all of
keep
these
clean.
can become problematic. Yeah. You're looking at the standard of care. Are the contractors falling below the standard of care?
Is it good practice, even if, in your opinion, if you have some sort of contractor come in to, even if it has no bearing on the HOA or anything within the CCNRs, to just say, hey, I'm having construction here. I need to let people through the gate. They're going to be here this long. Is it good to put them on notice?
The association?
Yeah, the association, even if it has no bearing, only for those particular reasons that they know there's going to be noise, there's going to be trucks, they're going to be parking X, Y, and Z. Is it good to put them on notice if it's potentially going to be a lightning rod?
I think communication is always good with the association, to the extent that the contractor's coming in based upon an application that was submitted, then the association arguably already knows and already has a timeline of work. They have a schedule. Now, if you're suggesting that this contractor is coming in on something that didn't require an application,
That's right.
is it best practices to notify the powers that be? Possibly, yeah. As a common courtesy, you might even want to notify your neighbors so you don't run into these disputes in the first place. But I think it depends on the scope and the nature of what's happening. And
Sure.
typically,
Yeah.
the larger scope construction issues or jobs typically require notice anyways to the association. So
Yeah. Oh, interesting. Okay. Let's jump into some resolutions.
Okay,
Went over a lot of the problems. I mean, this goes without saying. I mean, every HOA dispute, it follows a very similar template. But number one, document the issue.
yeah, document everything. I always encourage email communication, even if it's a phone call. Follow up with a email,
Just to review what was discussed.
just to memorialize.
So you get there's
yeah,
a problem
exactly.
with the neighbor. You take your pictures, take your emails, take your notes, start documenting as detailed as possible.
Exactly. And let's say you have a conversation with the neighbor, you may want to follow up with an email. It's like, dear Susie, wonderful talking to you. Hopefully we can get this thing resolved. Again, this is to memorialize our discussion, just to ensure clarity. Because often what happens is you have a conversation with someone and there's, sort of a rejection of that conversation down the line when it's convenient.
Sure.
It's harder to, sort of argue against an email. So emails are very important. Photographs, video, anything that you can do to back your position, yes, it's encouraged.
Yeah. Number two, review the governing documents. I'm assuming 9 times out of 10, this is going to be your best friend because your neighbor's more than likely breaking a rule within the CC&Rs.
Yeah, so once you frame the issue and you sort of have your head around it, it's always good to go to the CC&Rs. Understand that. Probably the best way to approach CC&Rs, because often they're quite dense, go to the index, try to triangulate that way, as opposed to just starting on page 1 and just go through the whole thing. Another tip, if you can OCR it, meaning you can do a Control F search within the CC&Rs, that's very helpful. But often, if you're in a dispute like this, you're often looking at certain terms: nuisance, noise, odors,
Those keywords, yeah.
Parking,
and it should be able to bring you to that section. If you can't do that, then just good luck. You're going to be reading quite a bit, but you should be able to skim
Hire
it.
someone in Bangladesh to read it for you.
Maybe
There you
outsource
go.
it. Maybe outsource it to a third party. But yes, governing documents are very important.
Because you're going to want to reference, I'm assuming you're setting the stage of, I got all the documentation I needed. Now I need to prove that this is the area that this is the area that they have violated.
You're isolating the provision or provisions that have been violated.
Yeah.
And that's the foundation of everything that you're doing. So take the flooring issue, right? If someone has installed hardwood floor, you want to be able to articulate pursuant to provision 3.2, you can't do that.
Yeah.
Absolutely.
Right? So
the next step would be just communicate with the neighbor, have that dialogue, have that discussion with the neighbor. You've got the evidence, you've got the violations that they have, and just communicate. And I would assume we just touched upon this, but email, even if you have a phone conversation, having a follow-up email to, as you say, memorialize it would be mission critical.
Communicate, try to work with the neighbor first. I think that's always the first. Start with the olive branch. You don't need to start with the sword. So,
Well, the keywords, in a calm and respectful manner.
well, I think that's true. I mean, a lot of,
You have to
sometimes,
live next to them.
Yeah.
correct. And if you can avoid a war with your neighbor, that's never a bad thing. So, yeah, be respectful. I think if you can identify the issue and be objective or reasonable, arm's length, it tends to go a long way.
Sure.
When these things go south, it's often a battle of wills at some point.
Yeah.
It's not. It becomes visceral in nature. You have something that seems sort of petty on its surface, that seems curable, becomes this huge thing, and once it becomes a battle of wills, the DNA of the dispute changes, and often it changes because someone comes at someone else very aggressively, and someone doesn't like that, and all of a sudden
Ego
they lock,
gets involved, yeah.
they lock horns.
Yeah.
So I agree with that tip.
All right, so that all fails. Communicate with neighbor. they either ghost you or they
Don't care.
They don't care. The next level the next, I guess, step was, well, when do you involve the HOA?
Yeah. So if you're not getting traction with the neighbor, let's use a flooring example or a noise or a commercial activity, and they say, we're not going to stop, we're not going to do anything. It may make a lot of sense to start working with the association at that point. And you can do that through just notifying them with an email.
Yeah.
And if they're not listening to that, then you can always escalate to the process, which we discussed quite a bit, which is IDR, which again is, you've identified it. It's informal dispute resolution. This is under the Davis-Sterling Act. But again, the spirit of that is allowing a homeowner an avenue to sit down with the board and discuss an issue face-to-face. Now, when I say face-to-face, it could also be over Zoom.
Yeah.
But by demanding IDR with the board, you can actually bring it to their attention, you can articulate it, you can sit with them, and you can try to problem solve.
And just to clarify, too, because I know we've gone over this multiple times, but I think it's worth the people that just are listening to this episode. IDR, requesting IDR is it's your right under the Davis-Sterling Act. It is a legal obligation for them to respond at that particular...
Yeah, people articulate that this way quite a bit, and there is a good faith underpinning to IDR, meaning that your association, a well-functioning association, will respond favorably to your IDR request. Now, when you say it's a legal obligation, I always look at a legal obligation in terms of, okay, if you don't do it, what's the ramification? And under IDR, unfortunately, there's no real ramification. So even if you say, yes, under the Davis-Sterling Act, I have a right to IDR, you demand it, and they tell you to go kick rocks, there's not necessarily some sort of punitive damage attached to that. Now, does it show bad faith? Yes. If you eventually escalate the dispute and it ratchets up, then yes, you can go back and say, hey, we tried to do IDR, they rejected it.
Or they ghosted you completely.
Correct.
Yeah.
That could be a very powerful piece of information down the road. But for the immediate, they rejected it, there's not too much you can do at that point other than switch gears and try to become more aggressive with the association. So that's IDR.
I kind of hate that there's no repercussions, especially coming off of that of Florida's just sweet new laws out there that there's so many more ramifications now.
Well, it's becoming more, according to Jeff, it's becoming much more punitive.
Yes.
And I've always been an advocate of making the violations more punitive in nature, because as I see it, you have an association. If they're a good association, what do they care?
Yeah.
If there's strong penalties for not doing something, but you're doing everything, why would I care that there's a massive ramification?
Right.
The only thing would be is that you're disincentivizing people from wanting to be on these boards at all.
Correct. But again, someone who's disincentivized, if you say, hey, if you act in bad faith, if you engage in fraud, if you harass someone, if you selectively enforce, you're going to get in a lot of trouble. And someone goes and says, oh, I don't want that hassle. maybe you're doing something good. It's like, listen, if California changed its driving laws to say if you drive over 150 miles per hour, 120 miles per hour, you're going to go to prison automatically for 30 years. I don't care because I don't drive that fast.
Yeah.
It doesn't impact me at all.
Sure.
So similar to this, I mean, if you ratchet up the ramifications, it might actually create a lot of good in this space.
So,
but I digress.
When do you bring on the attorney? I'm assuming if they blow off your IDR request, it's time to bring on an attorney. Okay.
If they ignore the IDR, quite possibly, or you go to IDR and it's a complete waste of time. It's a shouting match. They shut you down. They stonewall you. They back the neighbor for whatever reason. At that time, you want to maybe talk to an advocate or a third party.
Or I guess I was just thinking, and maybe you disagree, but what if the HOA is unwilling to do anything? They're just saying, "Hey, this is between you two. Don't involve us." Even though it's clearly they're breaking the rules and CC&Rs, but they're not going to do anything about it.
Yeah, so that's a sort of a stonewall. They're stonewalling you.
Yeah.
They're saying kick rocks.
Yeah.
So I agree. At that point, you determine whether it makes economic sense to bring in a lawyer, and to the extent that it does, you talk to a lawyer.
And our phone number is.
All right, Jenny. You ready
All right,
for
here we
the
go.
best part?
Okay.
we have a little Reddit segment that we found that Luke has not.
Yep, people
heard.
like this one. All right,
Yeah.
so let's see.
Okay,
right,
here we
Jenny.
go. My wife and I live in California condo with an HOA. Earlier this year, we discovered a leak in our ceiling. We initially called the plumber who had previously done repiping work for us. However, he confirmed that the issue wasn't related to his work. We then hired a second plumber who also determined that the leak wasn't from our pipes, but rather from our upstairs neighbor's unit. He advised that our neighbor needed to call a plumber to address the issue. We informed our neighbor, who then contacted his home warranty provider, but they refused to take action. His realtor subsequently brought in a plumber who advised that the bathtub, a 40-year-old fiberglass unit, needed replacement. However, our neighbor refused to replace it. Eventually, our neighbor hired another plumber who attempted minor repairs, such as replacing the drain and resealing faucet valves, but these measures were ineffective. The leak persists within 24 hours of each visit. Throughout this ordeal, we have kept our HOA and its management company informed, expressing our concerns about potential mold and structural damage. Unfortunately, they have declined to assist, considering it a personal matter between the two units. We also contacted our homeowner's insurance, but they advised that they could not intervene, suggesting instead that the HOA should be able to step in. At this point, we are unsure of our next steps. Is it time to consult a lawyer?
This has a lot of different entanglements.
Lawyer or
in
an
it.
expert? Yeah.
This is contractors.
plumbing
This
expert.
is all sorts of fun stuff in here.
Yeah, but it's actually, you can cut it to the bone pretty quickly. So yeah, I think a lawyer does make sense, lawyer intervention. I'm curious to see what the actual damages are. So how much water damage is happening? Because with water damage, I mean, that could be very serious very quick, especially with mold, et cetera. So let me back out. So first, the impacted neighbor would have a direct claim against the neighbor upstairs, right? That would be a negligence claim, most likely a violation of the CC&R's claim, and that could be run in. I suppose. I guess you'd go straight to ADR. It'd be an ADR demand to the neighbor if you wanted to be very aggressive, or you get a lawyer to just threaten action if they don't address it. Because maybe what's happening is the neighbor isn't taking it seriously.
That's what it sounds
Right.
like here.
They just say, well, I've done what I could. I can't do anything further.
Which is weird because if it's leaking and causing a problem at the unit below,
Correct.
it's certainly causing a problem with your own unit.
Correct.
But at what point is it structural to where it's more of the HOA's issue? not
Well, so
yours?
that's the other thing I would say. I would say that the association absolutely has an obligation to do something. And the reason is because if it's going through flooring, what's in between the flooring is often considered common area. So the actual building itself could be compromised due to this leak. Now, an association has a fiduciary to protect the building, to protect the common areas. And if they know that there's an active leak and they're not doing anything, that becomes a breach of fiduciary, that becomes negligence, that becomes a breach of CC&Rs. So you have two targets that you could hit very aggressively on this, if you wanted to. I guess if you didn't want to bring in a lawyer, you could always go the small claims route. California is $12,500 in damages,
That's not going to do it.
but
I just had a leak. I ain't going to come in
but
close.
let's assume for a second that it would. Let's say that we caught it early. It was $12,500 in damage. The issue that I see though is it's more ongoing. If they don't ever solve the leak, sure, you get the $12,500, you patch up your ceiling or whatever was impacted in your unit, and it happens next week.
Yeah.
So that's probably not going to work. So yeah, you have to get much more aggressive with this, but I would go after both targets.
What if they did something like incredibly stupid and just said, okay, we're just not going to use our bathroom or this particular shower anymore, and we're going to stop the problem. As a homeowner underneath them, it's like this is a time bomb. It's one mistake away from leaking again.
I'd say you still go after them, because how do you know with any certainty that they're going to comply with that?
Sure.
Right.
And two, there's already been damage. You know what I mean? It's not like, it's like spray painting a wall and saying, okay, I'll never spray paint that wall again. Well, you've already done the damage.
Yeah.
Yeah.
So just because you're going to forego spray painting in the future doesn't mean you cannot still be held accountable for what you've already done. And that's the similar
sense.
here. The damage, the water intrusion issue has occurred, so now it's enforcement. So this homeowner probably has a number of ways to enforce, and very meaningful and powerful ways to enforce if they wanted to.
Unfortunately, it looks like they haven't gotten traction with multiple people, so it's almost destined that they need to.
Well, because they've
they've
probably been
Kind of exhausted.
Well, here's what they've done: they've extended olive branches, and they're surprised that no one's listening to their olive branch, or they're not. They're probably negotiating kindly. Sometimes that doesn't work. Sometimes in order to procure peace, you need war. I mean, that's the unfortunate reality of these things.
That's dark.
That's dark.
Welcome to association law. I suppose it is, but it's the reality.
Yeah, I mean, you work in a form of war, I guess. That's what
I live on a battleship. That's all I see is war.
This is
By the
true.
time you come to us, diplomacy and peace discussions
Have been
that's
exhausted.
been we're done. We're not there anymore. We're beyond that.
Yeah, the Pentagon.
There you go. And so this individual is beyond that in my mind.
What a shame.
So, all right,
Well,
Marty, what do we got now?
That's it. Let's wrap it up and let's tease the next one: common area disputes.
Okay. That's a fun one. So common areas become also a lightning rod for disputes. Next episode, we're going to dive in deep on common areas, discuss what we see and how you as a homeowner can sort of fight back when you're dealing with a common area dispute. And often that's, the association is failing to maintain a common area,
Pool.
Yes.
a pool, a
Or
green
spa.
belt, all of the above. So that's a really good one. So
Don't mess with a
pickleball court.
a pickleball court or a spa in Florida. You'll have some angry retirees.
that might be
That's
true. So thank you for watching, and we'll see you next time.